Hello, thank you all of you for joining us today to attend our webinar. My name is Carol Westrop and I work in the General Counsel team of the SRA, and I'm joined today by our Head of Professional Ethics, Maria Round. Together we'll be talking you through some of the key compliance issues being faced by solicitor and small firms such as yours as a result of the coronavirus pandemic. And we'll outline some of the ways in which we can help you address these. You don't need me to tell you that these are unprecedented times, with all of us facing wide-ranging and significant societal and economic changes now and for the months and even the years ahead. Now, the coronavirus situation is an enormously worrying time for us all, including all of those involved in providing legal services. And we understand that many firms and solicitors face uncertainty and difficult business conditions. And we fully understand that the practical difficulties that the COVID-19 pandemic has caused, especially for smaller firms. Now, moving on to the next slide. First of all, let me tell you about how the pandemic has affected the SRA. So we've had to make a number of changes so that we can continue to operate as normal. For example, our 600 or so staff are now home working, including our ethics helpline and our contact centre. Aside from a few key staff, generally it's business as usual for the SRA, and we're including authorisation of firms, doing policy and guidance work as we would normally do. We've had to adjust our contact centre and ethics helpline and have been using callback, web chat and emails where possible. And we've also set up a dedicated COVID-19 management team to coordinate our response to the range of issues that we've seen as the situation has unfolded. And more about this from Maria and me shortly. Now, the best way to contact us is by email. Please do send us forms or any other documents by email rather than by post wherever possible. So our regulatory approach. Overall, we've tried to be as pragmatic and proportionate as we possibly can. Clearly, we can't change the law or legal requirements, but where our rules cause compliance difficulties, we've been looking at the flexibility we can provide, for example, by use of waivers. And this is always going to be a bit of a judgment call between relaxing our standards where we can and making sure that clients and the public are protected with the appropriate degree of protection. We've also made it clear that we won't second-guess difficult judgment calls made by firms about how to act in their clients' best interests in these challenging times. But we do expect you to keep a note or record of your decision-making so that we can properly look at the factors if we do subsequently receive a complaint about a particular issue. So, turning on to how have we dealt with common queries? Well, we've set up a dedicated team of key staff across the SRA to coordinate our approach to the high volume of queries we've received from solicitors, members of the public, trainees and others, including questions that we've received to our ethics helpline, from the Law Society, from accountants and other regulators, really about our rules and the potential impacts of COVID-19 on them. And we've collated all of these questions and our responses and are now displayed in a dedicated coronavirus section of our website. And you'll see the link on the slide to the home page. Now, we're continually updating these to reflect new developments and new emerging issues, such as coming out from events such as these. And we're sending you more regular email updates to make sure that you can access our materials. We've been attending virtual events such as this one to explain our approach and answer questions and make sure that if there are new questions that we capture these and also publish them on our website. And finally, we've been engaging regularly with the government and the Law Society in particular to make sure that we provide as an accurate and joined up approach as possible, and that our Q&As on compliance issues are reflected on the Law Society's website, for example, so it's easier for you to access. We would highly recommend that you read the guidance on the Law Society's website. They've got a large number of resources specifically aimed at smaller firms, for example, and they've done a lot of research on this topic. for example, highlighting the 5 essential issues faced by smaller firms around cash flow, compliance, and issues. So we would suggest you look at that, as I'm sure you will find it helpful when looking into this issue. They've also addressed some of the issues that we have covered in our Q&As, and which I'm now going to pass you on to Maria, who's going to take you through some of the detail of the question answers that we've received and our responses to them.
Thank you, Carol. So the compliance issues, one of the first we received was about virtual witnessing. It was an area that caused concern, and we received lots of queries on the issue as there was a spike in will writing for clients, particularly in nursing homes or shielding as vulnerable. So the issue for many firms was the social distancing rules and how to execute a will when witnesses needed to be present. This was particularly concerning for smaller firms who had fewer support staff available to attend as witnesses. We also had queries about documents, such as conveyancing documents that needed to have a wet signature. In all the cases, each time we spoke to the solicitors, they were very concerned. They did their very best for the client, and they wanted to protect the client's position, given the difficult circumstances the clients were also in. So our question and answers set out our position should a complaint be made to us after the event. So as Carol said, we can't make any changes to the legal requirements, but we can take into consideration, should a complaint be made, the surrounding circumstances and what you did to protect your client's interests. So when you are making those judgment calls, we would advise you to keep appropriate records of your decisions and how you arrived at them. And that way we can take them into consideration as mitigating factors such as Covid-19 restrictions, and we can look at those in the round. HM Land Registry has taken a tentative step towards accepting electronic signatures on deeds and relaxed some identity verification rules in their latest official response to Covid-19. So it's well worth you looking at that to see the kind of relaxation there is, which may be of help to you. There are also 2 practice notes that the Law Society produced some time ago on execution of documents by virtual means and execution of a document using electronic signature. So they were produced some time ago, but as I say, they are now working on an update cover paper to those practice notes to reflect the Covid-19 issues. They hope to issue them shortly, and we will put a link on our website, so that will be of help to you. We also know and understand that the Law Society are discussing the Wills Act and any other requirements there are through legislation and changes to legislation, so keep an eye out for that, as they may be successful discussions. Client ID was next on our slide, which is identifying a client when unable to meet them was a concern for the profession. The thing to note here is that you have a general conduct duty in our Code of Conduct for Solicitors to identify your client, but you also then have a specific duty under the money laundering regulations if you're in the regulated sector. So for those example that are doing conveyancing, they would need to understand that. The Code of Conduct for Solicitors, that's at paragraph 8.1, says you must identify who you're acting for, but we're not prescriptive in that, and so we leave it up to firms to determine what is necessary for them, considering all their clients, their staff and their arrangements. So you may then have or decide that it is sufficient to take ID by way of email, telephone, Skype, Zoom call, virtual appointments, and that's a decision for you to make. If you're in the regulated sector, of course, you do have the added duty to make sure that you look at your client's due diligence. And the best guidance there, and we have found the best guidance, is LSAG, the Legal Services Affinity Group guidance, which all the regulators have contributed to. And that gives you very detailed guidance on how to ID your client. And there is an update to that guidance which specifically deals with COVID issues. So do please take a look at their website because it's very, very helpful. They do deal with e-verification. It's obviously a good thing, but it does have its limitations. So again, I would point you to the guidance and also the guidance of the Financial Action Task Force, FATF, because that's also extremely helpful when you're talking about electronic due diligence. So moving on to the next slide was professional indemnity insurance, and we did take a lot of queries on this. Obviously, it's caused concern for a number of firms. Our general advice to all firms in the usual circumstances is to engage early with brokers and insurers way before you need time when you're renewing your insurance. However, we know that some firms are experiencing huge practical difficulties when trying to get in touch with their brokers, their insurers, or they have people within the firm that usually deal with this who are ill. We also know firms that have had trouble accessing funds to pay the premiums. So the Law Society is investigating government-backed and private sector facilities that could help firms struggling to meet the cost of those premiums. If you do need help, please do go to the Law Society website or contact coronavirus@lawsociety.org.uk, as they will give you support in these times. We will, of course, continue to monitor the situation with insurers, brokers and the Law Society. We are engaging with a number of firms, a small number of firms, that have entered into the extended indemnity period. And we've recently issued a question and answer on the subject, and that advises that if you're having difficulty and if you can't secure PII cover due to the practical difficulties of COVID-19, then you may be able to agree with your insurer to extend the EPP period and the cessation period, both or either. And if you can agree that with your insurer, then make contact with us at Professional Ethics so that we can deal with a waiver of our rules, so there are no barriers to you and that extension. Further on the slide here, we have the staffing issues. We did take calls and we took queries over email from staff who were concerned about safety in the workplace, whether they should attend work and whether there were protections in place for them. We would ask that all firms please follow the government guidelines in the first instance in terms of ensuring safety and accountability of staff. There were other concerns other than physical safety, and that was with regard to key role holders. So we do have a question answer on the position of COLP coffers and MLROs on our website, and we do say if a compliance officer is unwell for a short time, that you don't have to inform us, you don't have to take any further action. But if they're ill for a further period, so a longer period than say a month, then you would need to look at making a temporary emergency approval application. So do please take a look at that Q&A on the website. Impact of furlough was another query we received. And quite a few people would contact us and ask us whether they could carry out pro bono work or they could do voluntary work whilst furloughed from their firm. The government's guidance did make clear that volunteering opportunities could be offered for staff on furlough, as long as that work didn't generate revenue for their employer. So the Law Society has issued guidance on the subject, and we have confirmed in a new Q&A that we published today that we don't see that there are any regulatory or compliance issues with offering pro bono services during furlough times. Supervision is the last there on the slide. Again, we took a number of questions on this from firms talking about supervising their staff. Firms were concerned that supervision or the requirement to supervise staff dictated that staff needed to be in the office face-to-face to be supervised. But again, our regulations aren't prescriptive here. We leave it to firms to decide, take into consideration their staff, the size of the firm, their clientele. And we don't necessarily require face-to-face supervision. We do require sensible and appropriate arrangements to be in place to ensure that the client's matters are dealt with competently. So each firm will have systems to ensure that their compliance is effective for that firm. Again, we have a question and answer on our website, and those can be found in the education and training set of questions. So moving on to the next slide, which is the accounts rules. And accounts rules are always an area that solicitors have concerns about, because of course it's all about their needing to protect client money. So as you know, client money, once paid in, well, it has to be promptly noted, paid into your firm's client account. So firms were concerned that they would get checks in, the bank was closed, they didn't have the staff to go to the bank. They were most concerned about that. So we would say do your best in those circumstances to protect your client's assets. Maybe if you have checks, keep them in a safe. Tell your client what you're doing, explain to them the situation. Do please keep a note of the difficulties that you are experiencing and the judgment that you made. So if you are experiencing those difficulties as a consequence of COVID, then we would not say that that is a breach of our rules, but we'll take that into consideration. Another concern of the profession was that we would take disciplinary action if there were any delays in the obtaining or the production of an accountant's report. As you know, they're usually due 6 months after the end of the financial year. Again, we are aware that there will be difficulties here with getting the accountancy firm to deal with these matters. So we've set out in a question and answer that any delays to the usual accountancy arrangements caused by COVID-19 restrictions is unlikely to be seen as a breach of the rules resulting in disciplinary action. And because we would not see that as a serious breach of our regulation, then we would not expect a COFA to report that issue to us. So the final point there on the slide was about undertakings. Firms were concerned about undertakings that they'd already given, and of course undertakings that they would need to give going forward. We would advise you to try and cover as many eventualities as possible in any undertaking that you give. But where you can't comply because of government guidance or the virus and the difficulties, then you should let your client know, you should let the other side know as soon as possible. And it may be possible to come to some agreement with the other side that is in the interests of both clients. And actually, when speaking to the profession, that's what we found, that both parties have tried their best to come to some agreement. If a complaint is made to us about a delay in complying with the undertaking or non-compliance with the undertaking, then if this is for reasons beyond your control, then obviously we'll take those circumstances into account when we look at any complaint, and we'd be very unlikely to take any subsequent disciplinary action. So we're returning to Carol now to go through the education and training issues.
Thanks, Maria. So we have a separate section on our website dealing with education and training issues. We had a number of questions in the early days, especially from training providers who were concerned about how they would, in effect, run their assessments. Now, these aren't so relevant to you as our audience, so I'm going to concentrate on some of the more important issues that have been flagged with us about trainees and period of recognised trainings that perhaps some smaller firms might face. Now, we fully recognise that students, trainees and law firms are all concerned about the impact that the coronavirus has on their training and on their assessments. And our aim is to help by being as flexible as we possibly can, while still making sure that solicitors who qualify have met the required high standards that we all require. So I want to highlight two specific things. One is the professional skills course, or the PSC for short. We have confirmed that we're accepting applications from the providers of those courses to vary how they do the assessments. So they might temporarily want to move the assessments online or use devices such as remote proctoring to make sure that the assessments can be delivered. But we do know that there are going to be a number of cases where individuals can't complete the course in time for their planned admission point to the role. For example, a number of people wish to normally apply in September. So our recent Q&A confirmed that we are relaxing our requirements in this regard. So if a trainee isn't able to complete the PSC because of the impacts of coronavirus on them, they've been ill, for example, or because the course isn't being run, they can apply to us to defer completion, and they do that through the use of a waiver that we've made as simple as we possibly can in terms of the application process, and we'll deal with them as quickly as we can. And we will waive the PSC, which will allow them to be admitted as a solicitor, but we do still require them to do the course within 12 months of admission. So it's a conditional waiver. You can be admitted, but you will need to do the PSC within 12 months when things are hopefully a bit more back to normal. Now, to remind firms, our rules do require firms to pay for a trainee's first attempt at the PSC. This obligation continues should the trainee find that as a result of having been given a waiver, they have to take the PSC after admission. We've received a number of batch of questions, as Maria mentioned, in relation to the impacts of furlough, a kind of a new concept for us all. And particularly both on supervision of trainees when home working and when trainees are furloughed. So as Maria's covered, trainees, like all other law firm staff, can be effectively supervised remotely when they're working from home, provided systems, appropriate systems are in place, which ultimately will be a matter of judgment for you and your firms as to what's required. And we don't give any time limit on that, so there's no indication that you can only be appropriately supervised for a matter of weeks, and we know that the furlough scheme is likely to be extended by the government. So if trainees are furloughed when they're taken off furlough, and that might depend on the firm's arrangements as well as the length of the government scheme, the firms should discuss with their trainees whether their period of recognised training needs to be extended. Now, this will depend obviously on the length of time that they've been furloughed, and we will make a case-by-case, and firms should make a case-by-case assessment of whether the practice, the period of recognised training needs to be extended, or whether they in fact are able to meet the requirements of our practice skill standards that sets out the competences that we expect newly qualified solicitors to demonstrate. Generally, we think it will be difficult for the practice skill standards to be met if trainees are furloughed for 3 months or more. We just think practically that's going to be difficult to prove. So the trainee in those circumstances will probably need to extend the PRT. But again, this will be a case-by-case assessment by the training principal based on the person's experience, how long the furlough has been, and other factors, and whether they can properly make the assessment that the practice skill standards have been met. Our training regulations do say that trainees can be admitted when they're ready to do so. So they shouldn't be delayed from applying for admission if they've in fact met the requirements and the training principal feels it's appropriate to confirm that to us. And if there's any delay, for example, in that happening, we do have the power to recognise the period of recognised training ourselves. If the trainee doesn't meet the requirements, so the training principal thinks that because of the length of the furlough or for any other reasons that it needs to be extended, well, that's to the discretion of the training principal. But we do ask that if the period of recognised training is extended, that the training principal should notify us and tell us of the new end date. So there's a host of other issues on education and training on our dedicated education and training pages on COVID-19. So if you have any wider questions, please have a look at those questions to start with. I'm now going to just move on more generally to summarise really what's sort of next for the SRA and perhaps for you. Now, we obviously don't know how long the lockdown will continue for, and what the circumstances and consequences will be when it's lifted. And while it's very good for all of us to see that there's been some tentative movement, for example, in the property market in England and Wales that was announced yesterday in terms of viewing and house moves, clearly it's likely that firms will continue to face difficulties sort of well into the future. So we will continue to carefully monitor developments. There's lots of resources to help support you, particularly for smaller firms, on the Law Society's website. And we obviously have resources on our website as well. For example, some of you may have concerns about potential solvency issues, and the Law Society have recently surveyed a number of large, medium and smaller firms to find out how the pandemic is affecting them. And they have told us, and it's evident from the research, that smaller firms particularly are facing some very challenging issues around cash flow, and in some cases are under threat of potential solvency. So it may be helpful if I expand briefly on our position on financial instability. Now, there's a clear obligation, which I'm sure most of you know, on firms, including their managers and compliance officers, to monitor financial instability. These are set out in our code for firms, and it essentially says that you must actively monitor your financial stability and your business viability. And once you are aware that you will cease to trade, you affect the orderly wind down of your activities. And under 2.5, you must identify, monitor and manage material risks to your business, including that those might arise from your connected practices if you have them. And also, following on from that, as well as the duty to monitor, you have an active duty to tell us promptly if you become aware of any serious financial difficulties relating to your firm, of a relevant insolvency event in relation to you, and if you become aware that you are or you intend to cease operating as a legal practice. So if you become aware of any of those, we do ask that you tell us. And particularly if you need to close, as clearly we are concerned to make sure that clients' interests are protected. But unlike those of you who remember the crash post-2008, our emphasis will be very much on monitoring, logging the information and supporting any orderly closures insofar as we possibly can to make sure that the public interest and clients' interests are protected. And we will continue to publish further communications and guidance on these topics and liaise with our colleagues in the Law Society. Now, as part of our business as usual that I mentioned earlier, we are also continuing to publish non-COVID-19 related guidance. So, for example, in the pipeline, we're going to publish some further guidance on involvement in risky investment schemes, balancing duties and litigation, on undertakings, following on from the brief overview that Maria gave, and supporting mental health issues, which obviously is very much a key feature of all of our concerns, and we have dedicated resources on our website to support those who are suffering mental health issues, generally or caused by a result of the pandemic. Now, we know there'll be further challenges ahead as the government develops its post-lockdown exit strategy, and we start to move back hopefully to a more normal routine. And we're going to obviously to make sure that we the commitments and positions we've outlined during this period are reflected in future operational or guidance processes. We know from our conversations with the Law Society that they're liaising with the government to seek to obtain the greatest clarity possible on how the post-lockdown working arrangements will affect in particular legal services. But it is likely, as now, that there will be a degree of flexibility and interpretation by those of you who are running legal businesses or involved in the provision of legal services. And we don't think that these sorts of decisions are likely to engage our rules or have any compliance issues inherent in them. And as Maria said, the best thing to do is to keep abreast of government advice and the host of information that's on the government website. We do have a few calls, for example, perhaps surprisingly, that furloughed staff are saying their employees are making them or suggesting they work on client matters, fee earning work, when at home furloughed, obviously contrary to the government scheme. And if we were to receive any such reports, then we would consider whether an investigation might be appropriate into those circumstances in due course. So moving now on to our final slide. We asked in advance for any questions from you. Hopefully, we've covered many of the other questions which you might have offered. We only actually had one question, so I'm going to hand over to Maria to answer that question briefly, and then we'll come up for a short wrap up before we end this session.
Thanks, Carol. So the question that was raised was, how do we do checks for a politically exposed person, a PEP? What if the client cannot obtain up-to-date ID, i.e. dated within 3 months because they're isolating? So I'd advise really that you have a look at chapter or 4.12.2 of the Legal Services Affinity Group Guidance, which I mentioned earlier, Regulation 28 and 33 of the Money Laundering Regulations. These go into detail about what is necessary when dealing with a PEP, and as I did say earlier, it is incredibly helpful. We use it a lot when advising the profession, the LSAG guidance, and that's available on our website. For the ID point, I'm not aware of any regulatory requirement for ID to be dated within 3 months, either under our own rules about identifying your client or under the if you look at the money laundering regulations and LSAG, there's no mention of the 3-month rule, but I would refer you to the whole of the chapter of Chapter 4 of LSAG, generally for what CDD is required of firms, and then to the COVID-19 specific LSAG piece of guidance that has been recently published, and that again will be on our website, and hopefully that will be of great use to you.
So thank you, Maria. So hopefully this session's been useful to you. Thank you very much for all joining us, and for all of those within the SRA who've helped organise it, and especially Matthew, who's been running the operation so smoothly from a technical end behind the scenes. You'll see a slide there. If you have any specific query that we haven't covered or any issue that you want to raise with us, please get in touch by email or web chat to Maria's team, the professional ethics team. And we also have a small Teams virtual reference group for those of you who might want to join, where we will test or discuss issues relating to small firms particularly. And there is also on our website a dedicated supervision hotline and email address to our supervision teams, again, should you want to discuss any issues with them directly. So that's all for us for now. Thank you very much for attending, and please stay safe.